Maine's Democratic Secretary of State, Shenna Bellows, made a significant decision on December 28 by removing former President Donald Trump from the state's presidential primary ballot. This action was taken under the Constitution's Insurrection Clause, which prohibits individuals who have engaged in insurrection from holding office. Secretary Bellows' decision marks the first time an election official has unilaterally taken such action, and it comes as the U.S. Supreme Court is preparing to determine whether Trump remains eligible to continue his campaign. The ruling by Secretary Bellows follows a similar decision made earlier this month by the Colorado Supreme Court, which removed Trump from the ballot in that state under Section 3 of the 14th Amendment. However, the Colorado decision has been stayed until the U.S. Supreme Court makes a final determination on whether Trump is barred from holding office under the provision. The Trump campaign has stated that it will appeal Secretary Bellows' decision to Maine state courts. In response, Secretary Bellows has suspended her ruling until the court system rules on the case. Ultimately, the U.S. Supreme Court is likely to have the final say on whether Trump appears on the ballot not only in Maine but also in other states. Secretary Bellows based her decision on the fact that Trump's role in the January 6, 2021 attack on the U.S. Capitol violated Section 3 of the 14th Amendment. This section prohibits individuals who have engaged in insurrection from holding office. The ruling was made after several state residents, including a bipartisan group of former lawmakers, challenged Trump's position on the ballot. The Trump campaign immediately criticized the ruling, calling it an attempted theft of an election and the disenfranchisement of the American voter. Legal experts have noted that this ruling highlights the need for the U.S. Supreme Court to clarify what actions states can take under Section 3. While Maine only has 4 electoral votes, it is one of 2 states that split their electoral votes. In the 2020 election, Trump won one of Maine's electors. Therefore, if he were to become the Republican general election candidate, his absence from the ballot in Maine could have significant implications in a closely contested race. In her decision, Secretary Bellows acknowledged that the U.S. Supreme Court will likely have the final word on the matter. However, she emphasized the importance of fulfilling her official duty. Her ruling has been praised by former state lawmakers who filed one of the petitions that prompted her to consider the case. On the other hand, some Republicans in Maine have expressed outrage over the decision, calling it a sham, and comparing it to actions taken by third world dictatorships. The Trump campaign had previously requested that Secretary Bellows disqualify herself from the case, but she refused to do so, stating that her decision was based solely on the evidence presented during the hearing. The U.S. Supreme Court's decision on the matter is still uncertain, but both sides are pushing for a fast resolution. The Colorado Republican Party has already appealed the state high court's decision, urging an expedited schedule. Trump is also expected to file an appeal within the week. The petitioners in the Colorado case have requested an even faster schedule, hoping for a ruling before Super Tuesday on March 5. The Supreme Court must formally accept the case, but legal experts believe this is likely to happen. The Section 3 cases are seen as ideal for the Supreme Court to address, as there is limited judicial guidance on this aspect of U.S. governance. Section 3 of the 14th Amendment was added in 1868 to prevent former Confederates from returning to positions of power. It prohibits individuals who broke an oath to support the Constitution from holding office. While the provision fell into disuse after an amnesty for most former Confederates in 1872, it has been revived following the January 6 attack on the Capitol. Critics of the movement to bar Trump from the ballot under Section 3 have warned that the provision could be used in unexpected ways. For example, conservatives could argue that Vice President Kamala Harris is also barred from office because she raised bail funds for individuals arrested during the unrest following George Floyd's murder in 2020. These concerns highlight the need for the U.S. Supreme Court to provide clear guidance on the interpretation of Section 3.